A very good morning, good afternoon, and good evening to all of you, and welcome to this IPI seminar or webinar entitled Human Rights and Protection by UN Peacekeeping Operations. And right off the bat, I'd like to thank the Kingdom of the Netherlands and the Ministry, the France Ministry of the Armies, for their support in presenting this this webinar. Sorry, I may have started before this everyone's included in this meeting. So the subject of today's discussion is human rights and protection by UN peacekeeping operations, and we're all mindful of the most frightful and savage attacks that are taking place in Ukraine at the moment by and perpetrated by a permanent member of the UN Security Council. Tomorrow, we will be hosting a webinar on this issue, and I would urge all of you to attend, and we'll have some senior former UN officials look at the dilemmas that will inevitably will confront the UN in the days ahead. For today's purposes, we're going to examine the rather complex issue, the thematic issue, of how human rights sits within the peacekeeping context. For obvious reasons, there would be no peacekeeping operation or peace presence by the UN in any context where the human rights obligations of the state were being observed fully. The reason why we have a peacekeeping operation is that a conflict has resulted from the very deficit of the human rights observation that is required. And so beginning from 1990, that's right, the Security Council began to incorporate, of course, protection of civilian components, and over time, this broadened to encompass the human rights components on protection, and a number of instruments were contrived for that purpose. And protection is one thing, promotion is the other. To what extent does the UN then promote the normative standard across the board? So it's not just the right to life or to be free of course, exposure to anything like torture and forced disappearance, but all the other positive rights that are required for a dignified life. And so we're going to examine all of this in a context also where geopolitically, not only do we have a problem between the way in which things are viewed in New York as opposed to Geneva, but geopolitically we see, of course, the problems around the world and the pushback on the human rights agenda writ large. And so this presents us with certain difficulties, notwithstanding the trajectory we're on. So what is the current state of play, and what could be done to ensure that there's greater observation of human rights obligations by the member states concerned, and what is the UN's role precisely in this? And we are absolutely delighted to have a first-rate panel to join us and give us their opinions. But to kick it off, I would ask Her Excellency Ambassador Joke Brand, the permanent representative of the Kingdom of the Netherlands, to make some opening remarks. Ambassador, please, the floor is yours.
Thank you very much, Zeid, and thanks to IPI for hosting this this webinar today. We're very pleased to see everybody here, and of course, also great to be here together with my colleague from the French mission, Diara. And as you know, Zeid, we are very proud to be partnering with IPI on your work on protection and peacekeeping. As you said, I mean, I couldn't agree more. We are meeting at a really difficult time when we actually see, as you said, a P5 member being responsible for the violations of international law that we're witnessing in Ukraine. I think I can say on an hourly basis almost, and I think we're all shocked by that, and also by the humanitarian disaster that we see unfolding before our eyes. So I think it's now more than ever that we need to be clear that the protection of human rights and the adherence to international human rights law is not something optional. They need to be respected in all contexts and all places. In Ukraine, as much as in other places of the world, because I think we're talking about rights that in the Universal Declaration we have called fundamental and universally protected. So as you said, these are rights that are not only essential for the maintenance of peace and security, but that we also need to observe in order to avoid that we get into situations where we start, maintaining that peace and security. Obviously, when we talk about peacekeeping settings, I think it's important to keep on realizing that we need to make sure that first and foremost, of course, these peacekeepers themselves respect international human rights law, and as you said, then on top of that also contribute to promoting and protecting, promoting the respect for human rights. And I think we need to realize, of course, that the peacekeeping missions need to be an example here, and that we can never tolerate a culture of impunity for peacekeeping staff. There's already tools available. I think you also pointed out to that, where the UN works together to respect international human rights norms. We have, of course, the human rights due diligence policy that, when it was established in 2011 was a step forward, but I think much more needs to be done. And, when it comes, of course, to the current geopolitical context that you also referred to, we can, and you rightly referred to the pushback as well, Zeid. We can see that when you talk about integrating human rights in missions, it's going to be increasingly difficult. We now have the example concrete of UNAMA, which is not a peacekeeping mission, but still I think it's an illustration where we clearly see that when you talk to the Afghan people, we had a group of Afghan women over here last week. They almost feel that, human rights is like the core of the mission. So basically their message was, well, if it's not there, what is the point of the UN being there? But what we see is that pushback on any sort of human rights issues being integrated in that context. So I think it means that we need to, of course, continue to push for that, but also see, what other possibilities do we have within mission context to make sure that human rights are being respected. For instance, maybe we could also think about, working more closely together with some of the host nations to increase their capacity to perform better when it comes to protecting human rights. We can focus more on issues like accountability and reconciliation within missions. And of course, what we already do is training and providing guidance to troops. Maybe interesting to share that when we did the PrepCon for the Peacekeeping Ministerial last year, we got actually a lot of suggestions on better performance by peacekeeping missions on protection. And I think many of these would also support, better protecting human rights. So it's, I think, worth looking at that. So I'm very happy with today's panel, and I hope, and I'm sure actually, that they will able to provide us with insights and share ideas about, how to strengthen the tools that we already have available. But also, I think we are forced to look at, what other tools exist to better protect human rights. So let me once again thank you, Zeid and IPI, and all the panelists. Looking forward to hearing their thoughts. And let me, as a champion on the protection of civilians under the A4P agenda, conclude by reminding us all of the pledge we made in the Declaration of Shared Commitments that peacekeeping missions should use all necessary means in accordance with the UN Charter, mission mandates, and applicable international law to protect civilians. I thank you.
Thank you, Your Excellency, for setting the stage, so to speak. And we now turn to our second opening statement. As you mentioned, we're fortunate enough and delighted to see Diarra Limelabil, the legal advisor from the Permanent Mission of France to the UN. Diara, you have the floor.
Bonjour à tout le monde et merci beaucoup, Zeid. Really, I'm very happy actually to be here and to attend this webinar. And I really would like to thank IPA for organizing this, of course, with the support of France, a bit of self-promotion. And I would like also to thank Yoka, the permanent representative of Netherlands, as you know, for her participation. And thank you, Zeid, for moderating this discussion. And let me start by saying that this virtual event illustrates the dynamism of the Peacekeeping Observatory created in 2014 and the fruitful collaboration between France, the French Minister of Armed Forces, and IPI. We really welcome this partnership being renewed for another 3 years. But dear colleagues, as Yoka said, and even if Zeid was referring to a webinar that will take place tomorrow, I really want to start with a few words on the dreadful Ukraine situation and the really, really difficult time Ukrainian people are facing and living right now. It is really a real humanitarian tragedy that is being played out before our eyes. Russian aggression in Ukraine is killing civilians, including children, every day. And essential civilian infrastructure are being destroyed, leaving entire town without access to water and electricity. Hospitals, schools are under attacks, and I think that it is really important to talk about it. Maybe this is not the place, but just to add that France and the European Union stand firmly by Ukraine and its people. The absolute priority is an immediate cessation of hostility and full respect for international humanitarian law and human rights. And together with Mexico, I would like to let you know that we're working on a council resolution on this matter. It is also essential to ensure full humanitarian access to all people in need and to allow people trying to flee Ukraine to do so safely and unhindered. On a white paper and documentation we're going to talk about, our responsibility as permanent member of the Security Council and member of the Human Rights Council guide us to deepen our understanding of the mechanism of peacekeeping and to support the research on the protection of civilians and the promotion of human rights, a key priority of peace operation. And as Yoka said, we know that we are facing a lot of pushback when it's come to human rights, and we really definitely need to stand to avoid that. So that's why France and myself welcome the work done by IPI in this article, which summarizes the evolution of UN effort in this area and offer a clear analysis of the intricacy of implementing civilian protection mandate. It's also shed light on the importance for the mission to work in a more integrated way to strengthen the training of UN personnel and to ensure a useful transfer of human rights competencies in mission transition context. That's why we fully support the inclusion in the mandate of the task of protection and promotion of human rights, which directly contribute to the peacebuilding efforts. As mentioned, the work done by the Human Rights Division of the mission is crucial to play a warning role and establish a link with local community, which is really and definitely very important because we need to empower local community, the people on the ground, to make themselves and to work closely and collaborate with KEEP mission operation on this. The update and the regular documentation they provide on human rights violation and abuse and violation of international humanitarian law are key to adapt the mission scope. Another example of why associating the local communities is very important. And another scope or another way where they are very valuable in the fight is the fight against humanity. The Human Rights Division have a key role in alerting international stakeholders. In this regard, we will continue to encourage the UN to be more explicit in its human rights report about the denomination of the perpetrators of violation, such as the one regarding the Central African Republic, for instance, or even Mali. We will also welcome further analysis regarding the role played by women in the maintenance of international peace and security, ways to enhance women participation in post-conflict decision-making process, and to integrate even further a gender perspective into the work of the United Nations in peacekeeping operation. We were celebrating 2 days ago the International Women's Days. Of course, as a woman, I think that every day is an International Women's Days, but it shows how important women are in this process. Now, another self-promotion. Let me just emphasize a bit about what France is doing in this matter. As you know, the respect of IHL and the protection of civilians is a priority of action. And I think that you know that with Germany, we've launched in September 2019 a call for humanitarian action endorsed to date by 53 signatories. In the Council, we are advocating for the inclusion of language in resolution to ensure safe and humanitarian access. We also ensure that the protection of civilians remain at the heart of peace operation mandates. We took the initiative in 2008 to set up a working group on this topic at the UN Security Council. And again, we still and also advocate for the proper implementation of the UN Security Council resolution on the protection of civilians in order to protect population in vulnerable situations, especially women and children. Not that I'm saying that women are always vulnerable, but we know that in conflict, they are definitely sometimes very vulnerable. And we advocated for this priority during the C-34 negotiation. Our commitment is also operational, knowing the importance, as we call in this article, of the formation of our armed forces. We are carrying out numerous actions. In addition to our legal advisor, all our military personnel receive initial training in IHL, followed by an in-depth module in the event of deployment on external operation. In this context, we insist on the distinction between the two legal frameworks. On a national level, we have also set up a national IHL training plan for state actors in coordination with the RCRC and the French Red Cross. And it's not only on a national level, because France also helps and collaborates with its partner in this area. And I can say that since 2018, we've trained nearly 3,005 soldiers before their deployment in the specific requirement of peacekeeping, including for some IHL and IHRL. And has announced at the Seoul Ministerial Conference, France will continue its effort in 2022 and train more than 10,000 African soldiers. And we are supporting 9 peacekeeping training centers through the provision of inserted officials. And to let you know that this year, we are going to organize with the Organisation Internationale de la Francophonie, the 5th edition of a UN training of trainers session on a basic operational and ethical principle of PKO for the benefit of around 25 French-speaking officials. And then we are finally deploying an officer to the International Institution of Humanitarian Law in San Remo. I know I was a bit long on the self-promotion, but to conclude, we know that there is still much work to do in this area, and we remain committed to fulfill this demanding mandate. Peace operation and mission must be equipped with the necessary skills, with resources and budgets. We also have to mobilize UN staff on the ground to ensure effective protection of civilians. Mission must be exemplary in terms of behavior in order to carry out their protection mandate. We will have the opportunity to discuss this issue in a greater depth during this webinar. And I now leave the floor to you, Zeid, and to Conor Foley to discuss this article in good detail. And I wish we all a good session. Thank you. And sorry for being a bit long.
Thank you, Diara. And again, thank you both for your opening statements. And now we turn to our expert panel. I'd like to introduce them. To begin with, we have Mona Khalil, the affiliate at Harvard Law School Program on International Law and Armed Conflict, and one of the most brilliant lawyers the UN has ever had. And I'm delighted to say an old friend. We also privileged to have with us Regina Fitzpatrick, from the Protection of Civilians Team Leader, Policy Evaluation and Training Division, the UN Department of Peace Operations. Welcome, Regina. We have my old colleague, Oscar Solera, Peace Mission Support Section, Strategic Planning Team Leader, Office of the UN High Commissioner for Human Rights, speaking to us from Bamako. Welcome, Oscar. And finally, we have Professor Connor Foley, who's a professor at the Pontifical Catholic University of Rio de Janeiro. And welcome to you, Connor. I'm delighted to see all of you. So in turn, I'll ask each one to just provide some opening remarks, framing remarks. If I can appeal to you when you do so, to actually separate the two functions, the protection functions, which very much sort of attach themselves to monitoring the violations, the ensurance that there's a human rights due diligence policy in place, the screening, and the promotion functions, which is the normative sort of establishment. So when we talk about protection, essentially we're talking about peremptory norms, customary norms, a violation of, right? Most people understand. Promotion is something else. It's much more expansive. And for the other, or the rest of the UN, it's difficult to understand. So when you speak to these issues, please separate the two and tell me how you see the two fitting in the context of the UN's approach. So can we begin with you, Mona, if you could set the stage for us in clarifying the different terminology, what it means, and then sort of give us some idea of the multiplicity of UN roles when it comes to human rights and UN peace operations. Please, Mona, you have the floor.
Thank you, Zeid. It's been an honor to collaborate with IPI through the years, and especially now under the helm of your leadership. Grateful also to the governments of Netherlands and France for their support for these initiatives. And without further ado, I will echo those who spoke before me, yourself included, about this very dire moment we are in historically. It's not just Ukraine that is under attack, it is the rule of law itself that is under attack, aggravated by serious violations by the permanent members themselves, those who are entrusted with the safekeeping of the Charter, who have become its chief violators, whether it's the US, UK invading Iraq in 2003, or Russia invading Ukraine in 2014, and again, in these present moments of horror that we are witnessing across our screens, revealing that those entrusted with the maintenance of international peace and security have thus far been responsible for some of the most consequential threats to the rule of law and to international peace and security. It is really a sad day and a sad moment, and hopefully the return to the commitment that the UN 75 declaration, going back to the basics of the Charter, the fundamental principles, is in fact where we're heading next, and not to the horrors that brought us World War II and the Holocaust. So going back to the subject for today's discussion, the UN dialogue about international humanitarian law and human rights law generates, as you rightly noted, multiple concepts that are not always understood in the same way, either by those who mandate them or by those who must implement them. As a result, the human rights related mandates of UN peacekeeping operations are often conflated with other concepts, giving rise to unfulfilled promises and unmet expectations. To ensure greater understanding and more effective implementation, it is thus necessary to do three things. First, to clarify the terminology. Second, to recognize the multiplicity of the roles that the PKOs are mandated to play. And third, to capture the interrelationships between the various policies and principles of the UN human rights framework. First, the terminology. The POC mandate is distinct from several concepts and several other mandates. The broader human rights protection mandate, the responsibility to protect, and the customary international law and IHL framework for the protection of civilians and the sanctity of civilian life. Human rights protection is the much broader mandate of the peacekeepers mandate. It relates and is entrusted to the human rights component of a peacekeeping operation, promoting awareness and respect for all human rights, and monitoring and reporting violations on all, especially the most serious of both the IHRL and the IHL frameworks. But the POC mandate is something different. It is an affirmative, proactive mandate to protect civilians from physical violence and the threat thereof: killing, raping, torturing, maiming, murdering, beating, so on and so forth. A very narrow class of those human rights. It is also to the extent that it's focused on the physical violence and the threats of violence against civilians, much broader than the responsibility to protect, because the responsibility to protect is the third pillar of the Security Council's authority in very specific, narrow circumstances: genocide, war crimes, ethnic cleansing, and crimes against humanity. So this broader POC mandate, while smaller than the protection mandate, is nonetheless endowed with an authority to use force up to and including deadly force. This is very different from the IHL principles of ensuring no targeted attacks against civilians, of ensuring no indiscriminate attacks against civilians, and ensuring minimal collateral or no collateral damage against civilians. It is actually an affirmative responsibility to ensure the safety and security of civilians from physical violence and threats of physical violence, all physical violence. So as such, the IHL has a negative obligation to refrain from harming civilians, whereas POC is an affirmative positive obligation to proactively protect civilians. So these are some of the nuances between the various concepts that are bandied around when we talk about protecting civilians and peacekeeping. Second, we must also recognize the multiplicity of the roles. And these are not mutually reinforcing, although clearly engineered to ensure the same ultimate goal. In the short term, they may actually be competing. So on the one hand, a peacekeeping mission must promote respect and awareness of human rights. It must monitor violations and report them. It must investigate them in some cases. It must also use force to protect civilians as a last resort when all other means to protect civilians from physical violence fail or are deemed to be futile. It must also ensure cooperation with national, regional, and international efforts to ensure accountability for such crimes. So at the same time, a PKO is asked to build human rights into judicial capacity in the host state while monitoring and reporting the violations of that very same state, its government, and national authorities. It is asked to investigate violations of IHRL and IHL and cooperate with international and national criminal courts, while itself ensuring accountability for the violations of its own personnel and peacekeepers, whether by SEA or more serious crimes under IHL and IHRL. It is called upon to implement a POC mandate, if necessary, using force against both state and non-state actors who are deemed to be posing threats or actually attacking civilians, while maintaining a political impartiality in peace processes involving those very persons deemed responsible for such attacks or ordering them. So these are a few, but the overlapping and potentially competing roles that the UN peacekeeping operation must play at the same time. This is often aggravated by the fact that too often, in order to keep the consent of the host state, the support of certain members of the Security Council, and continued cooperation on the ground, impartiality has come to mean finding a midpoint between the parties to the conflict. It has become almost pro forma statements condemning violence and calling upon parties to respect the law without objectively adhering to the demands of the Charter, the Declaration of Human Rights, and the international customary law framework. So these balanced statements calling upon our parties equally to respect law often belie the scale and multiplicity of the violations of one party over another, rendering the statements often gratuitous, often pro forma, and not living up to the expectations of the peoples whose voice the Secretary General must echo, left to fend for themselves without a true advocate in the ranks of the highest echelons of the Secretariat. This is at the heart of the human rights upfront policy and the action for peacekeeping. When the former Secretary General put forward that plan as one of the fundamental bulwarks of the framework, it was about a cultural change, recognizing human rights and protection of civilians as core and priority responsibility. It was also about operational change, focusing on early warning, shared analysis, better coordination, capacity to respond. And it was also about greater political engagement, being more proactive with member states to generate political support for early and preventive action. The policy was fundamentally about expecting staff to act with moral courage that often is not matched by the leadership, and assuring them that when they so act, they will have the backing of HQ as well as accountability for when they do not. So backing when they do uphold the principles and accountability for when they do not. And this shows that the Secretariat's voice has often been muted or mooted because of P5 pressure or because of internal pressures seeking to preempt or appease those external pressures. Those entrusted with human rights mandates and rule of law mandates must be protected by UN leadership wherever and whenever they're called upon to call for an end to impunity from violations. And they are also equally responsible for ensuring that those entrusted with the protection of civilian mandates are themselves held accountable when they become the abusers and the perpetrators of those very violations. The human rights due diligence policy was an important step to ensure that the UN itself does not become an accomplice to crimes by those it supports. The human rights screening policy was to ensure that the UN itself is not deploying anybody with a criminal record or an allegations of IHL or IHRL violations. The zero tolerance policy against sexual exploitation and abuse was to ensure that we uphold the highest standards of integrity and ensure the highest standards of dignity for those we're meant to protect. And the SG's action plan, Action for Peacekeeping, was to recommit member states to these policies as well as to the international effort to protect civilians. So as required in point 9 of that agenda, we must practice what we preach. We must ensure that all those deployed in the name of the United Nations are trained in IHL and IHRL and understand the interrelationship and the meaningfulness of translating those principles and policies into their actions on the ground.
Thank you, Mona, for that exceptional opening sort of framing. I wonder if we can turn to Regina now. Regina, you've heard Mona. You've had extensive experience yourself in Yemen, South Sudan, Afghanistan. Do you agree with what Mona is saying? And does that basically reflect what you yourself have experienced in operations at the ground level?
Thank you, Zeid. Short answer, yes. I agree with most of that, but I'll explain a bit. But first, I want to thank IPI and the Kingdom of the Netherlands and France for hosting this event today, and specifically for inviting me to be here with you, and also to echo the concerns already raised about the situation in Ukraine and the critical need for the protection of civilians there today. As mentioned, I'm pleased to be here today specifically because I am biased, I admit. I come from a background as a human rights officer in UN peace operations. And I've spent years trying to bring the human rights and POC in peacekeeping closer together. And that's because POC and human rights aren't necessarily mutually reinforcing, at least in the long term, as Mona described. To reiterate some of her framing of the issue, I would like to emphasize that POC in peacekeeping is indeed narrower than human rights. The mandate is limited to protection from physical violence, so it's focused on the right to life and security of the person. But also in general, POC applies only in armed conflict, although the Security Council hasn't always seen it that way. So POC and peacekeeping is more narrow than human rights, but also POC and peacekeeping is in some ways broader than human rights. Because POC is not only about protecting civilians from violations of the law, it's about minimizing all civilian harm and conflict. And operationally, we have a comprehensive integrated approach to POC and peacekeeping. This has been emphasized in the A4P Plus initiative, which prioritizes strategic and operational integration. So this means that we have a broader toolkit to protect civilians than the traditional human rights methods. And to begin, of course, we are armed actors with legal authority to use force to protect. And in fact, that is our strongest comparative advantage in peacekeeping. We are also political actors protecting by supporting peace processes. And we have a plethora of other tools to protect civilians, like strategic communications, local conflict mediation and resolution, strengthening the rule of law, DDR, CVR, etc. So all that said about the differences between the mandates, the POC mandate in peacekeeping needs human rights. We have so many examples of human rights components' critical contributions to POC and peacekeeping. And these span across the protection and promotion spectrum that we were asked to address. I'll share just a few examples. Now, in South Sudan, human rights analysis combining data sets has helped to identify real-time critical hotspots and incidents requiring further investigations. This analysis has been leveraged to inform the returns process for IDPs from the UNMISS POC sites. and has led to the establishment of many temporary operating bases in the past year, as well as the deployment of force patrols to deter violence against civilians. And this has been effective throughout the country in different violent settings. In the Central African Republic, where we've seen a shifting of conflict actors over the past year or so, monitoring, investigation, and reporting from the human rights component has clarified the harmful impact on civilians. In the Democratic Republic of the Congo, the human rights component of MONUSCO has for years been contributing to the fight against impunity by supporting military justice mechanisms, especially for conflict-related sexual violence. In complex situations of misinformation and disinformation, where we're seeing civilians are often at risk, the information corroboration procedures used by human rights components can help extract highly reliable information. Human rights components also protect civilians, and this gets more at the promotion side, by building the capacity and will of national security forces to protect civilians. And as part of this, by implementing the HRDDP, which I think I'll leave for Oscar to elaborate on. And finally, human rights components are particularly critical in UN transitions and other situations where physical access is decreasing. Innovative methods for remote human rights monitoring help a mission to extend its reach, even where traditional monitoring and investigations are not possible. And human rights will often remain when a peacekeeping operation exits, whether as part of a special political mission or a standalone office. So human rights, therefore, is a critical stake in ensuring sustainability of the mission's protections efforts. Now, in the early days of POC and peacekeeping, I admit I was among the human rights skeptics, not because it was too robust or had any issues with the use of force to protect, quite the contrary. POC seemed like a kinder, gentler human rights, or to put it another way, a more palatable human rights, because everybody wants to protect people. As long as we're not pointing any fingers or even talking too loudly about who we're protecting civilians from. And this lack of emphasis on perpetrators is frustrating and inherently flawed, because of course we need accountability to interrupt cycles of violence. Peace alone is insufficient. And we can't effectively protect civilians without understanding who we're protecting them from, how that actor is harming them, and why. But more than 20 years after the first POC mandate in peacekeeping, we have learned and we have adapted. All of our POC policy and guidance emphasizes that threat assessments, strategic engagements, POC planning and operations need to consider the who, the how, and why. And human rights analysis is crucial for this. So having spent my time linking POC and human rights, I do want to end by saying that I appreciate the distinction between the mandates too. The dual reporting line of the human rights component in peacekeeping can help to preserve political space for the mission. And also for POC, we need to leverage all mission information and analysis, not just from human rights. Other components have different sources and perspectives that contribute to a whole picture. And finally, maintaining both human rights and POC mandates in peacekeeping mainstreams protection. As I said, in the early days, there was skepticism about the kinder, gentler human rights. But we have seen the power of the POC mandate to bring people around to human rights principles in peacekeeping. And while I would never be in favor of POC instead of human rights, I now consider POC as basically an effective gateway drug for human rights. And the more allies we get on board, the more people will be protected in armed conflict. Thank you.
Thank you, Regina. And you spoke to an issue which very much resonates with me in the sense that for it to work properly, the entire system has to work. There has to be strong leadership and an orchestration from the top all the way down to the particular office that's tasked with doing this. And if there's a weakness anywhere, the whole system is very radically affected by it. If I can turn to my old colleague, Oscar. Oscar, give the audience a feel for what a human rights component does in a mission. And in particular, if you could provide us examples from MINUSMA, I'd very much appreciate it. And say some nice things about your old boss as well while you're doing it. Oscar, the floor is yours.
Thank you very much, Zeid. I was actually going to do that. Thank my former boss and IPI for the invitation, as well as thank the governments of the Netherlands and France for their support in this important task. Let me maybe first say I concur with my previous colleagues, but I would like to add a few layers of complexity, if I may. First, a very generic statement that I totally agree with is human rights is not POC. POC is not human rights, but they are like brothers, and they work hand in hand and should work hand in hand. Fortunately, they are not the same, because as Regina said, POC mandates cover a scope that human rights itself does not cover. Human rights covers a wider scope than POC, and fortunately so, because we can actually focus on things like economic, social, and cultural rights that are usually falling outside the scope of a POC mandate. Let me first start, because one of the questions I was asked to address was, how does the UN address human rights in peace operations? And the question was framed as, how does OHCHR? So let me begin by clarifying roles and responsibilities. I think that's important. OHCHR, as my former boss very well knows, is a department that has the lead on human rights issues. It supports peace operations. It provides key advice, resources when possible, but also political support by the High Commissioner to the mandate of peace operations. We do have, and that was a very great invention, the notion of integrated missions, to have human rights components in peace operations. And I use the term peace operations in general, because I know that most of the colleagues have been referring to peacekeeping. But I think that, as in the introductions by the ambassador and by Madame Dim, referred to also other contexts that have peace operations but are not peacekeeping. Reference was made, for instance, to Afghanistan. Afghanistan is not a peacekeeping context, yet it has a human rights component in UNAMA, in the mission in Afghanistan, and it has, in fact, a sort of protection of civilians mandate. We can call it like this, but we can call it something else, but it's still a mandate on protecting civilians. So the notion of protection of civilians, as Mona initially said, yes, it's a bit undefined. I think gladly so, because it gives us a lot more flexibility in the types of work that we do. And so I'll go concretely into examples. What human rights components do, and colleagues have referred to the what is POC. Let me tell you how we do it. Mandates in peace operations entail usually monitoring, reporting, investigation. So those are the key elements that we will try to see in a Security Council mandate for a peace operation. These key elements are essential. Monitoring allows the mission to have resources, to have human rights officers to deploy to the field and engage with victims, witnesses, civil society, state actors, non-state actors, etc. Though it is the main, let's put the main contingent, if I can use the expression, that the mission will have to gather information. And this can be done through different means. That can be through direct contact. It will be gathering evidence by physical deployments. And in that respect, the human rights component will always work in an integrated manner with the mission, because it cannot deploy on its own. So it will depend, of course, on the force. It will depend on UNPOL, the UN police. It will depend on other units or sections in the mission to be able to gather sufficient intelligence before deploying, and also sharing information after deployment. And in that respect, the monitoring leads to the reporting part. Now, the reporting part can be divided in different things. It can be divided in the traditional instruments that is expected from a mission, and that is public reports. Someone mentioned, I think it was Regina mentioned, to the finger pointing. Well, that's the finger that the mission has. Public reports are precisely the tool that the mission will use to identify perpetrators, to identify the violations, and to provide recommendations. Now, the recommendations, I think, are important to bear in mind. This is not just for the national authorities. There are also recommendations that are addressed to the Security Council members, for instance. There are recommendations that are addressed to the international community present in the country or in the region. So these recommendations are going to be hopefully the tool that the international community and the mission can use to take actions that can lead to either capacity building, as Regina said. It can lead to technical assistance, but it can also be used by Security Council members, hopefully, to call for accountability in the Human Rights Council and in the Security Council. So these are elements that are a must in a mandate by a Security Council. Now, there is an additional element. Some missions have it, and that is investigations. So investigations are a more in-depth type of process whereby we will investigate specific incidents of violence that will entail a longer effort, and that could actually lead to yet another report, public report, but that can also lead in some cases to ideas of or recommendations to refer cases to international jurisdictions like the ICC, for instance. That can happen. It's a recommendation that has been formulated on several instances in the past. Again, these reports are basically providing the factual, the analytical, and at the same time, the recommendations for the Security Council. These three elements are key. These are the pillars that human rights components will require. There are additional tools. Some of them were mentioned. HADDP. HADDP is a tool to ensure that whatever engagement the UN conducts with security forces will be beyond reproach. And that means the UN will only engage with non-UN security forces that have not committed human rights or IHL violations. And that entails that the missions will have to conduct a risk analysis of the different partners that we are supposed to engage with to determine whether we can collaborate with them or not. There are other tools. More recently, we launched an initiative with the support of both the African Union and the European Union to develop compliance frameworks in several contexts. And that means we're working directly with national armed forces so that they develop their own accountability mechanisms, including normative mechanisms, to ensure that their troops act in accordance with IHL and human rights. But there are other mechanisms that we should also bear in mind. Mona mentioned human rights up front. Indeed, that's a very important one because that calls on the UN to act in a certain way. There are others. The Secretary General call to action on human rights is another tool that provides us hints and instruments on how to act. There is also the Secretary General's common agenda, which is another element that should be borne in mind. And the broader human rights mechanisms should not be obviated in this. I mean, OHCHR has a role, human rights components have a role. Now, oftentimes, and Zeid, you asked me to refer to the Mali situation, or I can also refer to the MINUSCA situation that Madame Dinda was referring to. There are instances where the mission is stuck because of the political situation, because the pressures on the mission, because the consequences that a particular situation has on the work of the mission. And this is where other human rights mechanisms come handy. Special rapporteurs of the Human Rights Council, treaty bodies, and even the Human Rights Council have the ability to also work on these very same human rights issues and help the mission address human rights concerns that the mission itself may be a bit more limited to do. The High Commissioner is an instrumental voice in this role because the High Commissioner will be able to say things that are more difficult for other actors to say. And finally, I don't want to end without saying that the Security Council has a fundamental role in protecting human rights. And whatever we do as OHCHR, whatever we do as a mission, whatever we do as a human rights component is practically useless if the Security Council is not on board. The support of the Security Council members is essential, not just to give the mandate, but to do something with the products that missions produce in terms of human rights and to ensure that member states are actually accountable for their actions and take action on the recommendations that we provide. Thank you very much.
Thank you, Oscar. And it's not just the Security Council, of course, when you have a representative of the Secretary General PNG because of a report issued by the Human Rights Mechanism, the Secretary General has to support that SRSG, and it hasn't always been consistent that. Professor Foley, can we turn to you? You researched this extensively and written about this, and clearly, as has been pointed out by Ambassador Brown, there is this whole aspect of credibility that you're asking the UN to protect and promote, and increasingly so over time, as we've seen, and the confusion that has resulted in terms of the definitions and how these components mesh. But the credibility issue is always being tested. When I served in peacekeeping, I mean, the number of violations were legion. We had peacekeeping units trafficking in weapons, trafficking in fuel, trafficking in human beings. We had, sexual violations of a rather grave nature. And someone said to me once, if you see SEA in a peacekeeping operation, look deeper, because you probably find a lot that's not working well, a lot that would seem to be rotten about the whole presence. Could you speak to this issue and tell us, your view in terms of what progress the UN has made, what progress the UN hasn't made, and what more can be done to integrate these provisions, the international human rights provisions, into peacekeeping operations? Please, Connor, you have the floor.
Thank you very much, and thank you for inviting me. Thank you to IPI for organising this event, and thank you to the Dutch and French governments for their support in sponsoring it. I'd also like to extend greetings to Oscar and Regina, who I've worked with over the last couple of years. I've had various in-depth conversations about both these issues with you both, which were extremely stimulating. With Regina in particular, in relation to evaluation of civics work on protection of civilians, and with Oscar in relation to an evaluation I did of the OHCHR presence in Iraq. And more recently, I was actually talking to Oscar by Zoom on the same moment that this invitation arrived. I'm currently doing a consultancy for the UN team of experts on conflict-related sexual violence. And I was just kind of struck how small a world it is that we all seem to come together around these issues of rule of law, protection, human rights, international legal frameworks, and so on. But I'd also like to, if I may, at risk of embarrassing Mona, echo the remarks that Zeid made, because really you are, when the history books are written, your trailblazing work on the legal normative framework around the protection of civilians and the intermeshing of international human rights law and international humanitarian law and Chapter 7 mandates and the principles of peacekeeping, the 3 core principles of peacekeeping, and what that means in terms of on the ground getting protection to people, to vulnerable people in situations, and the advice and the strategic guidance you've given really has been phenomenal. So it's a pleasure to be on the platform with you and to have had your feedback on various things that I've written in the past. As has been said, we stand on a very difficult time. The horrors that are taking place in Ukraine, the flagrant violation of the principles of the Charter by a permanent security member, echoed only by what happened previously in Iraq when the US and the UK similarly ignored the basic principles of Article 2 of the Charter, are a sobering point. And I think there's some points perhaps we can turn the discussion towards as to what happens next. In particular, I think one encouraging thing about the developments that we've seen around Ukraine is the reconvening of the United for Peace meeting by the UN Assembly. I think only the 10th time it's happened since the first meeting in response to the UK and French vetoes after during the Suez crisis. So I think perhaps something we could positively think about is what does a United for Peace General Assembly Council do in relation not just to Ukraine, but broader. I mean, it was Uniting for Peace which led to the creation of the first peacekeeping mission, the UN expeditionary force to Suez Canal. And perhaps this is something we should, and I'll sort of end on this, perhaps there's some issues here that we could potentially explore as to what does it mean when we have, and we know we have, permanent Security Council members prepared to ignore the Charter, prepared to ignore basic principles of international human rights and humanitarian law when it suits them. What is the General Assembly's responsibility when the Security Council fails to exercise its responsibility to protect? That came up in a context a long ago around RTP, which I don't want to talk about, but perhaps there is something about human rights monitoring, reporting and advocacy that the General Assembly has responsibility for recommending measures, and what might those measures mean? That means some kind of action. What in practice could that mean in terms of promoting and protecting human rights? And to clarify, I'm talking about the key human rights: right to life, protection against torture, protection against slavery, and protection against genocide. So maybe that's something that we can address in the discussion. My own background, I'm billed as a professor, which sounds very grand. I actually, I first went to my entry on my first field mission was in 1999, and I'm reminded of it a lot looking at Kosovo. During the Ukraine, during the crisis in Kosovo, I was asked by the Council of Europe to go to refugee camps and to provide training on international human rights law and humanitarian law to help the investigators for the ICTY, who were at the time monitoring for violations and who eventually brought criminal charges against Slobodan Milosevic over his brutality in Kosovo. I'd previously worked for Amnesty International and for a UK human rights organisation called Liberty. I'd had some involvement in the McCann case, which was the first case brought to the European Court on the right to life in the context of what may or may not be called a conflict in relation to Northern Ireland. I actually knew one of the victims of the case. And I am still a fellow of the Human Rights Centre at the University of Essex, who have done much of the spade work to establish the international jurisprudence around the concurrent and extraterritorial applicability of international human rights law and international humanitarian law in relation to a number of conflicts, Southeast Turkey, Chechnya, Georgia, and elsewhere. So my kind of background as an activist was that, and that's why I went to the field. I was then seconded into UNHCR as a protection officer, and I was in Kosovo. In fact, my last day of my contract for UNHCR was the 12th of September 2001. So I was promptly sent off to Afghanistan, where my working for a partner of UNHCR, the Norwegian Refugee Council, setting up legal aid clinics. And I spent a decade in the field, going from mission to mission, sometimes working for the UN, sometimes working for NGOs, all around the issues of protection, legal reform, security reform, and protection of civilians. Finishing up in 2009 in Sri Lanka during the bloody end of that conflict, by which point my wife, who's a judge in Brazil, was pregnant. Our son was born later the same year, and so my field days ended in 2009, and that's when I became, if I am, an academic. Well, that's when I started teaching at university. But I continue to do consultancy work on these sorts of issues. And one of the first consultancy projects I was asked to do was by the Department of Police Operations in 2010. OCHA and DPKO, as it then was, had commissioned a review of the protection of civilians. And one of the recommendations of that was to provide more scenario-based training on the type of situations that peacekeeping personnel, particularly soldiers, might be an occasion to use force, and bearing in mind core principles of peacekeeping, the legal framework of Chapter 7 mandate, IHL and IHRL. In what circumstances might they and must they use force to protect vulnerable civilians? And one of the things that struck me at the time, I spent the best part of 2 years, 2010 to 2012, working on that. First as a kind of generic training, and then working in specific missions. I spent some time in Yanoki, MONUSCO, UNAMID, and UNMISS. Was how very much at that point, I'm talking 2010, 2011, 2012, protection of civilian, POC mandates, was seen as primarily a military task. It was regulated by IHL. There was a Secretary General's bulletin on the applicability of IHL, and people saw their task. I mean, the decade I was in the field, 1999 to 2009, that's when POC established itself as a normative framework. The first mission mandate was Sierra Leone, and during that time, it became accepted. I think it's now beyond dispute. Rona might disagree with me, but I think it's beyond dispute amongst legal scholars that POC has a normative framework. The Security Council can use its powers under Chapter 7, preservation of international peace and security, to protect vulnerable civilians. No one would really argue with that. And that's actually a significant legal innovation. I mean, something that the UN was set up to keep the peace and not to save the world. But I think in that decade, 1999 to 2009, it was generally accepted that the UN Security Council has a right, and indeed even sometimes an obligation, to use its Chapter 7 powers to protect vulnerable civilians. And so if that argument was one, the second argument, which I found on the ground, and I remember particularly when I was in Côte d'Ivoire and also in the DRC, people understood that they all, particularly military personnel, understood that they had this mandate from the Security Council to protect civilians. They understood they had to abide by international humanitarian law. They had to avoid collateral damage. They couldn't attack civilians. But there was less understanding about how that related to international human rights law. And I'd like to pay tribute to Mona and to Regina in particular, who I think have helped to bridge that gap. I think, as Regina says, POC is now seen as complementary or even a gateway into international human rights law. The positive obligation that international human rights law recognises, that the state authorities have an obligation to protect civilians, is seen as very complementary to the type of obligation that you find in a POC mandate, that security personnel, peacekeeping mission, may and sometimes have to use force, but it should be proportionate, it should be for specific means, it should be as a last resort, and it should be for protective purposes. And that's quite different from the concept that most soldiers have, conditioned by IHL, which is that you use force to win victories. And that's been a debate that's gone on within missions and within headquarters and with academics and pressure groups that surround them. Say, in what circumstances do we use force? And my argument, and I apologize to anyone I've irritated by making this argument, is that international human rights law provides a protective framework within which mission personnel need to be more and more familiar. And it's great to hear that there's the French government is training people on IHL, but I think it's important that, because still on the ground, it comes across that mission personnel, particularly military personnel, are more aware of their responsibilities and their obligations under IHL than they are under IHRL. And the policies and mandates have already been mentioned: human rights due diligence policy, action for peacekeeping, the agenda for protection. So I don't need to repeat them all there. But I would just say one thing, and this will be my final point. It's interesting, and listening to Oscar, it's very true that the human rights components in peacekeeping missions have done an amazing job. And actually, those human rights components have given the international human rights movement, OHCHR, as a UN part of the movement, probably a greater footprint on the ground than it's ever had before. I mean, if you look at how big the human rights components of a standard peacekeeping mission are, it'd be 30, 40, 50 people who are on the ground monitoring. And as the UN transitions out of peacekeeping, as those missions wind down, as they get replaced by special political missions, and I can understand the reasons for that. There's political reasons, financial reasons, and in some cases positive reasons, in some cases because the mission isn't needed anymore. I think something that I'd like to see a debate about is, how do we refocus those resources, that political will, that ability to get a greater human rights monitoring, reporting, advocacy presence on the ground? Because I've just done an evaluation of the OHCHR presence in Iraq, working on monitoring and accountability. And basically, they hired 4 UNVs with some money from the American Embassy to double their presence on this particular issue, monitoring accountability for the violence that was perpetrated against people who took part in the protests in 2019. And that seems to me to be quite a thing to think about. I mean, if we can save money by not having so many soldiers in some of these places, surely there must be a way to put more of those resources to increase the monitoring and advocacy purposes we can put on the ground in special political missions, in UN country teams. I mean, how do we get more resources there where they're needed? Because the Security Council has a huge, I mean, apart from Chapter 7 and peacekeeping troops, I mean, it has a huge role in diplomacy, in economic sanctions, in using its voice. So maybe there's something that we're missing here, and I don't know what it is. You're more connected to the situation on the ground than me, but can we find a way to use this transition to increase the human rights monitoring and advocacy that we do on the ground? So thank you very much for that, and I hope we can follow up that discussion as we open up the floor.
Well, thank you, Connor, and I think you rounded it up very nicely. You ignored the point that a question I raised with you, but I'll forgive you and I'll come back to it again.
I think the UN soldiers are basically good. I mean, I've lots of friends who work for the UN. I think it's a good organization, and they get a very bad press. So I'm not going to add to that at this particular moment. There are worse enemies that we have.
Look, if I was going to take a skeptical view of what it was you said, I would look at Ukraine now. I mean, it's very difficult to watch the bombing of that maternity hospital in Mariupol and believe that we've made any progress whatsoever. And the yardstick is the safe area concept. So you're absolutely right, 1999, first inclusion in explicit terms of a protection of civilians mandate, but it actually existed earlier with the safe area concept in Bosnia. And the reason why we never had a reapplication of this concept in Iraq or Syria, and dare I say it's going to come again in Ukraine, is because there's no stomach for it. There is no willing to really do it. Yeah? And what happened is that we went through the Kosovo experience. We deluded ourselves in that there was a change, there was R2P, and we put it into the resolution. And then from then on, you begin to expand it. But if I can be a skeptic also with regard to our monitoring, the Human Rights Monitoring Mission in Ukraine has come up with 32 reports, an extensive monitoring of rights violations throughout Ukraine. How many times do you think those reports were cited in Security Council debates? I mean, you'd be astonished, right? And the arguments that the Russian Federation make about the violations against Ukrainians who are not of a Russian ethnic origin, well, it's all there in the reports. Why don't the rest of the membership cite the reports? There's something very distinctly not working, and that is somehow we have to come back to it. What is it that's not working? And why is it not, or let's go back and say, why is it not working? And what is not working? And then how do we fix it? So I'm going to start off with Mona. I'm the skeptic. I've been in peacekeeping. I've been in the Security Council. I've been in human rights. Convince me that this is something we can fix. Mona.
How to fix it? Because I agree with you that it's broken. Are you asking for how to fix it?
Yeah.
And what it would take to fix it? I mean, I do think that going back to the basics is our best recipe, is our best path to success. Because the charter wasn't, as many of you have heard me say a million times, it wasn't some hippie flower child dream. It was actually the result of one of the bloodiest human conflicts, the worst genocide in the history of humanity. It was as a result of lessons that we shouldn't have to relearn, that the early warning of human rights is the best recipe for prevention of conflict. We're too reactive, we're always responding, we're always managing conflicts, we're not trying to prevent conflicts. Part of that is in respecting the duties, not seeing them as powers, but seeing them as responsibilities. The council is the worst failure of all, because it was meant to be the guardian of the charter, not the prerogative and the discretion and the prestige of being a permanent member, but the responsibility, the affirmative duty, the working together to prevent such atrocities, not much committing them, as we've seen multiple. And I don't think It's the US and UK are in a sense bad messengers of the message against Russia today, because they were the first to break the cardinal international supreme crime of aggression when they did what they did in 2003 against the clearly stated will of the international community and of the Security Council itself. So that's what's broken, is that those with the power do not recognize their own responsibility and their own accountability. And that somehow we have surrendered the entire international legal framework to the veto, as if that's the only rule of international law that we respect, and we wipe our hands and pretend that we're helpless in the face of the veto, when in fact we're not. Those permanent five should be reminded, and France has recognized this by virtue of its initiative with Mexico to ensure that the veto is not used when we're facing crimes of aggression, breaches of the peace, crimes against humanity, the genocide, the most horrible crimes. But we need to ensure that the veto isn't the only rule of law that we respect. That when there's a veto, and I'm grateful to Professor Foley for reminding us of the Uniting for Peace. I was told many a time that I was beating a dead horse every time I mentioned Uniting for Peace, because it hadn't been invoked since in the late 1990s. But finally, we see it kind of reemerging on the arena. And it's not just words on paper. Uniting for Peace is almost poetic in its preamble, in its appeal that we live up to the responsibility and the promise of the Charter. And it's not just condemnation. It can be an unconditional call for withdrawal, for military ceasefires, for cessations of hostilities, for sanctions, for military assistance, for arms embargoes, for peacekeeping missions. The only thing a Uniting for Peace resolution cannot do is refer a matter to the International Criminal Court, because by virtue of the statute, that is not available. But it can do anything up to and including authorizing the use of force where there's a breach of the peace, where there's an act of aggression, as we have here, as we did in Iraq, as we have genocides throughout the world, and the international community, the General Assembly, did not live up to its authority and, I would say, responsibility to respond when the Security Council was prevented from doing so as a result of a veto.
Mona, can I ask you a question relating to the Office of the High Commissioner of Human Rights? I mean, you are the senior legal advisor there. How much can that office accomplish under the mandate of the protection and promotion of human rights, which is not defined what that means? And you could take an expansive look at that, and you know, you don't have to be Antonio Cassese to see that you could drive quite a large part through it, right? Or what are the limitations to what it is that office can do?
I mean, I don't think it's as much a limitation in what they can do. It's a limitation in what weight and what enforcement is given to the pronouncements of the High Commissioner and the Office of the High Commissioner for Human Rights, as well as the Human Rights Council itself. I mean, you have full scope investigation, whether through the human rights components and or through other initiatives, including the commissions of inquiry that are established. You have the most powerful voice, and that is the voice of the voiceless. Member states don't need the voice of the High Commissioner or even of the Secretary General, frankly, because they have their own voice in the system. It's the voice of the voiceless that must be heard. And the High Commissioner's voice should be loud, should be clear, and should be concrete. And when she or he speaks, it should be allowed to speak freely and protected and endorsed. And that's not just for the Secretary General, it's for member states at large. It cannot be seen as a luxury to have that voice. That voice needs to be brought into the Security Council on a regular basis to provide early warning. Ultimate decision-making rests with the members of the Security Council. Nobody's interfering with that. But the information must be held up. It cannot be hidden. The voice must be heard, it cannot be muted. And those who are implementing those mandates on the ground should feel confident that they will be protected when they call a spade a spade.
Yeah. Do you agree, Regina? We go through this in order. Are you broadly in agreement with Mona on this?
I am. It's always hard to follow Mona because she covers everything clearly and comprehensively. But I would just emphasize in here, I'm obviously not speaking on behalf of peacekeeping, but that, you know, as Mona said, the positive, the progress we've made has often come off the worst experiences we've had. And so I would suggest that we should suggest a potential moment of hope or optimism in that we do see the world, most of the world, uniting around the situation in Ukraine. And there is, you know, almost certainly compared to where we are in peacekeeping operations, unprecedented, interest, prioritization, concern. And so, for whatever reasons that is, and of course there are challenges that come along with that, but we should seize this opportunity and try to have, and we, the international community, make as much progress on all of these suggestions as possible. But then I also just want to emphasize that has to be consistent. That needs to apply everywhere, not just in the Ukraines where everyone cares about them. That needs to apply in the other conflict zones, and the international community, needs to pick and choose a little less and be more consistent about which conflicts they're going to stand up for human rights principles and the protection of civilians.
Yeah, I think the point that has been raised by all of you is that it's always easy to talk about international human rights law when there is no friction, when you don't feel the contact. And you're always advancing to the point where there is contact, where you're hitting a nerve, and that's precisely where you need to work. And so often the rest of the UN is very ill at ease on these issues. So for instance, Oscar, how does one prioritize, right? If you're a component within a peacekeeping operation, and you clearly see what has happened, the deep roots to the problem, which is not just the alienation of a population, but structural discrimination against a particular population on grounds that are well established, right? And so the very conflict has morphed this into a conflict between competence. But the cause of it is the structural discrimination, the willful deprivation of people of their rights. How do you devise a strategy to go straight to the heart of the problem, right, and take the rest of the UN with you when they're likely to say, no, easy, let's just focus on disengagement, let's focus on ways to deconflict, but do it gently. You human rights people are going straight to the heart of it. And it's much better to use euphemistic language and talk about, all-inclusive policies and so forth. So run us through something like this. How do you devise this? And in a context where, let's say the right to life has been so trampled upon, to begin to advance, for instance, the idea that they should accede to the second additional protocol of ICCPR and abolish the death penalty, right? It's too far for many people in the UN and many member states. So how do you devise the strategy to promote and protect at the same time?
With great difficulty.
Your sound is muted a little bit, Oscar. If you can raise it. Yeah. With great difficulty, you said.
Sorry, no, I was saying with how do we devise it with great difficulty. Let me be very, very honest and frank. I mean, when we are in the context of a peace operation, there are competing priorities and competing functions. So it is always going to be very difficult to devise a strategy that goes to the heart of the problem when you have those competing priorities. We sometimes do. And I think here we should, someone mentioned earlier, the dual reporting line. So for those who are not familiar with that concept, the head of the human rights component is both the main advisor on human rights for the head of the mission, but is also the representative in country of the High Commission. And that is an advantage. That is an advantage for the UN system, because sometimes when the mission is not in a position to say something on human rights because of the pressures and the political implications, the High Commissioner can say those things. And so it is a question of how to use it and when to use it. It is often possible, and I said with great difficulty because there is a lot of coordination and articulation with other interests, but it is always possible to design a strategy either that will go either through the mission or through the High Commissioner or through both or through other entities in the system. Now it requires a great effort and coordination. It requires guts, if I can put it like that, bluntly. And it requires courage by the mission leadership to take on these difficult issues and know that maybe they will be PNG'd. And assume that if that happens, as some of you have said, that the system will back them up and say, don't worry, we have your back. Now, it is difficult for SRGs to know what's the limit, to know where to push it. And I think that we have still a long way to go to ensure that SRGs know that it's not just the Secretary General who will have their back, that are others, like the High Commissioner, like the Special Advisor on the Prevention of Genocide, like this Special Representative on Sexual Violence or Children Against in Armed Conflict. All these protection mandates are there to support the SRGs. And if I can go back to your original question, Zeid, about human rights reports and they're not being used, I do think that part of the fault is on us. There is such an overflow of information on every single conflict that to pretend that because we put out human rights information, member states will automatically take it up is a dream. In my current functions, what we're trying to do is actually try to help member states get the information, digest it, so that it becomes usable to them, because of the amount of competing information is such that it's hard. So if we want human rights information to be seen in member states' statements, we have to go the extra mile and put it in their statements, help them put it in their statements.
Yes, I really think with regard to Ukraine, there should have been a snap report at the end of the year summarizing the state of the human rights observation in Ukraine, and that would have blunted, I mean, so obvious were the exaggerations by the Russian Federation, it perhaps would have blunted at least the opinions of some countries that may abstain or did abstain in the Council, or could abstain or did abstain in the General Assembly. And so I think that's broadly right. I think going back to Uniting for Peace, the critical point here is mass and density of votes. Yeah, and it means that the system has to really pull together, and the system has to be firm. What I worry about, and this is something our previous boss, the late Kofi Annan, made clear in a number of his reports, is that when you're negotiating with a murderous adversary or murderous interlocutor, and you're still invoking some sort of sense of impartiality, you are creating a deep hole for yourself. And to try and get one's mind around that, I think one has to go back to the antecedents. It all begins with rolling out the protocol map at the General Assembly. It's treating them with a dignity that sometimes they don't deserve. It's the pushback that the whole system needs to provide, and understand that there's a deep moral component and not just a sort of superficial impartiality that someone has to adhere to. And I think in that context, one can see the General Assembly playing a critical role. But I think the maintenance of the voting is critical here, and it's not always assured, as we've seen in some of the conflicts. The voting pattern tends to be quite significant at a high, but the more you resort to the General Assembly as you build up to the Uniting for Peace outcome, the greater the risk that you actually lose votes in the interim, because the picture seems to be muddy and there's a lot of misinformation, which takes us back to the integrity of the reporting provided by the human rights components and the rest of the system, the POC components, when it comes to the UN. And I quite agree that I think greater effort needs to be made to present this before the members of the council. Having been on the council myself, I can attest to it. Yeah. Connor, would you agree? We're coming close to the end of our time. I'd like you to sort of say something, and then we'll sort of do a quick round, and hopefully this will lead us to set up some other panel where we can take this discussion still further forward.
Yes, I certainly would agree. And I would also perhaps just emphasize that the magnitude of the current crisis is not unprecedented, but it is comparable to things like, as you said, the genocide that took place in Bosnia-Herzegovina and Rwanda, things, I mean, or the Suez crisis. And in a sense, I mean, we do have, Obama said you should never let a good crisis go to waste. And perhaps we are on the cusp of something where what we mean by protection of civilians and international protection of human rights could start to begin to be redefined. So I think it behoves us all to be thinking through, I mean, what Mona said about what the General Assembly can do, and the ICJ case on certain expenses says exactly that. It can recommend measures, but what does recommend measures mean? I think getting the nuts and bolts of that would be massively important. I think that the second point would be to readdress the veto, and I think that the French and Mexico proposal is excellent. That's happening. I think we should also, I know it just sound like a stuck record on it, but go back to the membership of the Security Council. On the 10th anniversary of Sergio Vieira's death, I was involved in an initiative by the Brazilian government. We organized an event, and including which the Brazilian government brought ambassadors from Germany, Japan, India, Sierra Leone, South Africa, to actually look again at the structure of the Security Council. And that clearly must be having 5 permanent members based on what happened at the end of the Second World War is something that surely must be reassessed. Unfortunately, Brazil no longer has the same progressive government that it did at the time, although we're hopeful that we might have a new one by the end of this year. But I think that one of the kind of disappointing factors in the General Assembly resolution was that although the resolution condemning the Russian act of aggression was passed overwhelmingly, there were more abstentions than we would have wished. And I think that's something that we need to go back again to see with some of the countries that abstained, who are not necessarily, certainly we're not supporting the Russians, but are looking at Western democracy and saying things like that. So maybe there is some kind of refounding that we need to be thinking about through the Security Council, through the Assembly, through the Office of the High Commission and the various mechanisms. It's very nuts and bolts details, and I think academics are not the best place to say what are the levers to pull or buttons to push. But I'd agree with you very much that it's something we should follow up. So if it's possible to continue these discussions, I certainly think that would be a very good thing to have.
Well, thank you, Connor. And I think this is, you know, there was this line in Chitty Chitty Bang Bang. The reason I remember it is I watched it so many times with my young children. But the scene of the old men around the car, and they sing this song that out of the ashes of destruction grow the roses of success. And so let's hope that we see some roses in the future. I think the frightful conditions in Ukraine, but not just limited to Ukraine. I mean, continuing in Yemen, continuing in Syria, continuing in Libya, continuing in so many parts of the world. They have to, at some stage, be brought to an end. We have an enormous challenge with climate change. I mean, we are all imperiled by that in a very short few years. These other issues somehow must be made resolvable. We have to resolve them because the common threat that we face from these larger issues is so serious for us. And there must be that realization too. We must sort of grow up, or as Hammarskjöld said, member states need to become finally mature and not sort of almost behave in a childlike transactional manner. With that, we won't have time to do a final round, but may I extend my thanks to all of you for your participation. And forgive me if I went slightly off piece, but that's what I normally do. There's some questions I was told I had to ask, and I just didn't, so I'm going to face the wrath of my staff, and I apologize to them in advance. But I'd like to thank all our online audience as well for attending this particular panel discussion, and to the Kingdom of the Netherlands and the French government also for supporting us. I would also like to point out that IPI is going to release a policy paper authored by Damien Lilly on the UN Agenda for Protection, and please have a look out for that. Thank you, all of you. Thank you, dear panelists, and I hope we can do this again sometime. Thank you.